Welcome back, dear students. Today we are going to learn how to draft an agreement to sell a flat or any other immovable property. Dear students, you must know as to what is an agreement to sell and what is an agreement and how it is prepared. Can it be oral? Can you draft an agreement without any oral conversations? Is it possible to draft an agreement without prior negotiations? And dear students, you also know the law that agreement to sell a movable property like your car can be made orally without any written or registered instrument, but an agreement to sell or purchase an immovable property can be made only by a registered instrument, because the law says so that any agreement to sell or even sale deed can be made only by a registered document. I am giving you one illustration, dear students, that if you want to purchase an immovable property like your flat in Noida, what you will do? You will meet the prospective seller, or if you do not know the owner of the flat, you will probably contact some agent or property dealer. Property dealer will ask few preliminary questions to you about the location where you want to purchase the flat, size 2 BHK, 3 BHK or 4 BHK, valuation, your budget regarding the purchase. And the dealer will show you so many flats in Noida according to your need. You will select the flat, and on selection of flat by you, the dealer will take you to the real owner of the flat. Now, seller and purchaser are in front of each other. Negotiations will take place. The terms and conditions will be settled. The total price of the flat shall be settled. The amount of earnest money will be settled, and the time limit for legal formalities will be fixed. And time limit for final payment will also be fixed between the parties, and date of actual delivery of possession of the flat shall also be fixed while sitting across the table. When all the terms and conditions are settled orally, now both the parties will go to a lawyer like you, requesting you for drafting of an agreement to sell. Then your advocate will draft an agreement to sell the flat. Now you are the advocate. Dear students, you are the advocate. You are going to draft an agreement to sell. So this exercise shows that initially one party gave an offer to another for sale of the flat. The offer was accepted by other party, and there was some lawful consideration, say 1 crore rupees between the parties. And there is no illegality in this agreement. This agreement was not against any law, and this agreement is legally enforceable. So the equation, when you purchase or sell, you make an agreement to sell the flat or immovable property. The equation comes out to be like this, that one party gives the offer plus other side accepts it. So it becomes a promise. And when promise is coupled with lawful consideration, say of 1 crore rupees, it makes an agreement. And agreement, when it is legally enforceable, makes a valid contract. And this exercise, my dear students, again shows that before an agreement is executed in writing, oral agreement is a must. A written contract is nothing but a memorandum of what was orally agreed between the parties. But if law requires that a contract has to be in writing, then it must be in the shape of a written document. And if the law requires that this agreement should be registered, then it has to be registered also. According to section 54 of TP Act, what is sale? Sale is a transfer of ownership in exchange for a price paid or promised to be paid or partly paid and partly promised. How sale is to be made? Sale is a transfer of tangible immovable property which can be made only by a registered instrument. And the contract for sale of immovable property is a contract that sale of such property shall take place on such terms as settled between the parties. Such a contract can be made only by a registered instrument. And dear students, you must know that a contract for sale, which we are going to draft today, does not of itself create any interest or charge on such property because it is mere an agreement. It does not create any interest or charge on the immovable property unless through court it is specifically enforced. So I wanted to distinguish between the two types of contracts. We can have two contracts. One is contract for sale, known as agreement to sell. This is the initial contract. And second is the contract of sale, that is final sale deed. The contract for sale, that is former one, former contract creates no rights in property to be sold, whereas the later, that is final sale deed, transfers the property from seller to the buyer. And legally speaking, the contract for sale is not essential. You can go directly for sale deed also. Generally, in India, parties initially agree for a contract for sale. They give some advance money, and after a gap of agreed time, they go for contract for sale. Meanwhile, they make arrangement of money. Maybe they are taking some loan from some bank, or somebody is selling another property. Somebody is selling the jewelry or the gold ornaments for purchase of a flat. So the gap between agreement to sell and sale deed is being utilized for these formalities. And if some law says that permission of certain authorities is required for sale of property, then during this period that permission can be obtained. So dear students, with this much background knowledge with us, now we will start the actual drafting of an agreement to sell a flat. This is a contract for sale. We are not going to draft sale deed today. We are going to draft only an agreement to sell. So beginning has to be done like this. This agreement is executed on this first day of January 2017. This is the date of agreement and its heading is contract for sale or agreement to sell. Now name of the parties are to be drafted by you, complete residential address. So this agreement is executed on this first day of January 2017 between A, son of B, aged about 40 years, resident of flat number 918, Pavilion Code 10, JP Greens, Wish Town, Sector 128, Noida, Gautam Buddha Nagar, UP, hereinafter called as the vendor, which expression shall, unless repugnant to the context or meaning thereof, mean and include his heirs, successors, legal representatives, administrators, executors, nominees, and assigns of the first part. So A, son of B is our first party. And who is the second party? X, son of Y. All names are imaginary. X, son of Y, aged about 45 years, resident of flat number 906 Designers Park, Sector 62 Noida, Gautam Buddha Nagar UP, hereinafter called as purchaser, which expression shall, unless repugnant to the context or meaning thereof, mean and include his heirs, successors, legal representatives, administrators, executors, nominees, and assigns of the second part. So, seller and purchaser. Suppose after this agreement, either of them dies or both of them die, then this agreement shall be binding on their legal representatives. Now, the history of the deed starts. History of the agreement starts. And it starts with the word whereas. Whereas the vendor is the absolute owner of 3 BHK property bearing flat number 906 Designers Park, Sector 62 Noida, Gautam Buddha Nagar UP, built upon an area of 2000 square feet, more specifically described in the schedule annexed hereunder, and with boundaries thereof marked in red color for better clearance and delineated on the map or plan annexed hereunder, hereinafter referred to as the said property. The property to be sold is being referred here as the said property. So this is the history of the deed as to how the vendor is the absolute owner of the property which he is going to sell. And the further history is, and whereas the vendor has declared and represented to the purchaser that he has acquired the said property by way of inheritance from his father, Shri C, who died intestate on 20th December 2016, leaving behind only the vendor as his sole legal heir. So this is the history that how vendor became the owner of this property, that he inherited this property from his father, who died without writing any will or wasiyat. That is, his death was intestate, leaving behind only the vendor as a sole legal heir. And whereas it is also history, and whereas the vendor has declared and represented to the purchaser that said property is a self-acquired property of his father, late Shri C, who had purchased the same from Shri ML, son of NL, on 1/1/2016, while registered sale deed dated 1/1/2016, which is duly registered in the office of Sub-Registrar Noida, District Gautam Buddha Nagar, in register number 1 at pages 345 to 356. So this paragraph also reflects the history as to how the vendor is the absolute owner of the property. So in one of the paragraphs, we have mentioned that vendor inherited this property from his father C. And in this paragraph, we have declared the history that father of the vendor C purchased this property from Shri ML, son of NL. And that sale deed is also dated 1/1/2016, and it is duly registered in the office of Sub-Registrar Noida. Third paragraph, and whereas the vendor has further declared and represented to the purchaser that the said property is free from all encumbrances, charges, gifts, liens, attachments, mortgages, liabilities, unauthorized occupation, tenancies, claims, and litigations whatsoever, and the vendor shall keep the said property free from all encumbrances till the conclusion, execution, and registration of the sale deed in favor of the purchaser. So this is the declaration and commitment of the seller that property is free from all encumbrances. And whereas another history is, and whereas the vendor is interested to sell the said property, and the purchaser has agreed to purchase all the rights, title, and interest of the vendor in respect of the said property for a total consideration of ₹1 crore, subject to terms and conditions appearing hereunder. So this is the summary of what was agreed orally between the parties. You have created a memorandum in the shape of agreement to sell. This is the history. Now starts the operational part of the deed. Now, therefore, this deed witnesses and parties here to agree and declare as under. Para number 1. Now this is the operative part of the agreement to sell. So first paragraph relates to condition number 1, that the vendor shall sell and the purchaser shall purchase whole of the said property bearing flat number 906 Designers Park, Sector 62 Noida, District Gautam Buddha Nagar UP, built upon an area of 2000 square feet, including all the right, title and interest in the land beneath it, building, fixtures and fittings thereof, more specifically described in the schedule annexed thereunder, and with boundaries thereof marked in red color for better clearance and delineated on the plan or map annexed thereunder for a total consideration of rupees 1 crore only. This is the first term and condition between the parties. Number 2, that the purchaser had paid a sum of rupees 10 lakh to the vendor by means of a check number so and so, dated 1/1/2017, drawn on SBI Parliament Street, New Delhi, and the vendor admits and acknowledges the receipt of the same. This is also a consequence of oral agreement, that it was agreed that purchaser will give rupees 10 lakh in advance. Para number 3, condition and terms number 3, the purchaser shall pay the balance sale consideration of rupees 90 lakh only to the vendor at the time of registration of sale deed, and the vendor has agreed to it. Para number 4, that the vendor has handed over the vacant possession of the said flat to the purchaser at the time of signing of this agreement, and purchaser admits and acknowledges the receipt of possession. Dear students, generally the possession is delivered when entire money is received. Sale deed is registered, but depends upon the terms and conditions and agreement between the parties. If some builder wants to hand over the possession by merely receiving 10% of the sale consideration, it is his risk and choice. If parties have so agreed, then law has no objection that why possession was delivered when only 10% money was received by the builder. Depends upon the terms and conditions between the parties. Then para 5. The vendor shall obtain income tax clearance certificate required under Income Tax Act, along with other certificates and permissions required for the sale of said flat within 6 months of execution of this agreement. So 6 months time is for completion of formalities, and this period is the essence of this agreement. However, in case the vendor is unable to do so for any reasons and the proceedings for permission remains pending beyond 6 months, then until the final orders of the authorities concerned in that connection, the period for execution of sale deed shall automatically remain extended beyond 6 months, and the vendor shall, however, inform in writing to the purchaser immediately upon the receipt of all said permissions for completion of the sale deed in terms of agreement. So this period of 6 months is likely to be extended if permissions are not obtained by the vendor. Now suppose vendor is not doing anything, he has received a sum of rupees 10 lakh and he is keeping mum, he is not executing the sale deed. What will happen? Para 7 will answer this question. In case the vendor fails to obtain requisite permissions or certificates and fails to complete the sale deed in terms of this agreement, the purchaser shall be entitled to obtain the necessary permissions required under law on behalf of the vendor at the cost and expenses of the vendor. Besides that, purchaser shall have a right to get this agreement specifically enforced and implemented through court of law without prejudice to his other rights. So if Wendy is not obtaining permission, he is delaying, vendor is not doing so, then Wendy has a right to apply for permissions for the sale deed. Then para number 8, vendor has declared and represented to the purchaser that the said property is free from all encumbrances, charges, liens, attachments, mortgages, liabilities, tenancies, claims, litigations, etc. And it has been agreed that if any error, misstatement, or omission is discovered in this respect, the same shall not annul the sale deed, and the purchaser shall have right to specifically enforce this agreement. The vendor has further agreed with the purchaser that in case the said property or any part thereof is lost from the purchaser on account of any defect in the vendor's title or its right to transfer possession or quiet enjoyment of the said property, or the purchaser is in any way disturbed on account of any litigation in respect of the title of the said property, the vendor shall defend such action and will be liable for all costs and expenses sustained by the purchaser or caused to the purchaser as a result of such litigation. The vendor accordingly expressly agrees to keep the purchaser harmless and indemnified from against all the costs, charges, and expenses which the purchaser may sustain or incur by reason of any claim of whatsoever nature being made by anybody in respect of the title of the said property. Para 9. In case any party hereto commits breach of the agreement, he shall be liable to pay damages to the other party. If the purchaser fails to pay the balance amount to the vendor shall have a right to forfeit the earnest money of rupees 10 lakh. And if the vendor fails to execute the sale deed in favor of purchaser and fails to apply or obtain the requisite permissions for completion of sale deed, or any defect is discovered by the purchaser in the title of the vendor over the said property, then purchaser shall have the right to recover double the amount of earnest money from the vendor. However, this would be besides the rights of the parties to enforce specific performance of this contract. Dear students, what is mentioned in para 9 is a very common custom that if seller fails to execute the sale deed, he will return double the amount of earnest money, and if purchaser fails to get the sale deed executed in his favor after payment of balance money, then he loses his earnest money paid in advance to the vendor or the owner of the property. Para 10. That the vendor shall be liable to pay all rates, taxes, charges, and other outgoings of municipal corporation or any other authority or department up to the date of handing over the vacant possession of the said property to the purchaser, and it shall be responsibility of the purchaser to bear and pay all other rates, taxes, and charges and outgoings as will become due and payable for the further period after the date of taking vacant possession of the property. So up to the date of sale deed and possession, it is the liability of the seller to pay the taxes. After the date of sale deed and after taking possession, it is the liability of the purchaser to pay the government taxes. Para 11. The purchaser shall have right to have the sale deed in respect of the said property executed in favor of his nominee, and the vendor shall not raise any objection in this behalf. This clause is also very common in India to be added in the agreement to sell, that purchaser can get the sale deed executed in his own name or in name of his nominee. Next, para 12. Stamp duty, other costs and expenses for preparation, execution, and registration of the sale deed shall be borne and paid by the purchaser. Dear student, this is a very strong custom in India that stamp duty charges, typing charges, advocate charges, registration charges, all are a charge on the pocket of the purchaser. But this has to be mentioned in the agreement to sell very clearly. And now the signature of the parties and two attesting witnesses are also required on this agreement to sell. And this last paragraph will begin like this. In witness whereof, the parties have set their respective hands on this agreement on the day, month, and year first above written in the presence of the following witnesses. So first of all, vendor will put his signatures and then purchaser will also put his signatures if the agreement is drafted as bilateral one. Of course, agreement has to be bilateral one on which vendor and purchaser, vendor and vendee both will sign it. Then witness number one, his signatures are required. Nowadays, the photograph of both the parties and photograph of both the witnesses are also required to be appended on this agreement to sell. And complete address of witness number one, say it is C, son of D, resident of flat number 510 Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP. And witness number two, his signatures are also required. And his complete address has to be mentioned, like suppose he is E, son of F, resident of flat number 511, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP. And then, dear students, a very important part of agreement to sell is schedule of property to be sold. A great care has to be taken while drafting this portion of the sale deed, because more than half of the litigation in civil courts is pending mainly because of misdescription of property which was sold or which was to be sold. So very carefully you will have to draft this portion of this agreement. That is, this paragraph will begin like, all that property 3 BHK flat, area 2000 square feet, bearing number 906, situated at 9th floor, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP, bounded and butted as under. See, these words are important. The property to be sold is bounded and butted as under. On the northern side of the property to be sold, flat number 905 is situated. And on the southern side, flat number 904 is situated. On western side, flat number 907 is situated. And on the eastern side, flat number 910 is situated. These flat numbers 905, 904, 907, 9010 are not going to be sold. It is the property number 906 which is going to be sold by virtue of this agreement to sell. And dear students, nowadays, since the multi-stories buildings are constructed in NCR area, in schedule of property, you are supposed to mention what is on the top of the flat to be sold. So top side is flat number 1006 and downside is flat number 806. And site plan of the said property is also to be appended in the sale deed. Then comes the signature of the vendor along with his photograph, signature of the purchaser or the vendee along with photograph, and their photocopy of their Aadhaar card is also to be made part of this agreement to sell. Photocopy of PAN number is also to be attached along with this agreement to sell. Similarly, the photograph of two witnesses is also required. Witness number one will put his signatures along with photograph and his complete name and address, like he is C, son of D, resident of flat number 510, Designers Park, Sector 62, Noida, Gautam Buddha Nagar. And likewise, witness number two will put his signatures along with his photograph and his complete name and address, like E, son of F, resident of flat number 511, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP, is to be written here. And dear students, one more item which is now being added in the sale deeds and agreement to sell, that is addition of geotagged photograph. Geotagged photograph of the building to be sold. What is the benefit of geotag photograph to be added? It fixes the location of the property. Normally, the builder has shown you that the tower shall be raised on a particular sector, say it is sector 62, but actually that tower is raised in sector 63. So this is a cause of so many civil disputes in civil courts. So geotag photograph of the building to be sold is to be added, is to be annexed along with, is to be annexed in this agreement. This is to avoid the location disputes relating to immovable property. So this geotag photograph of the building gives you the idea and correct location as to where this building is situated. It gives you in degrees the longitude and latitude of the building also, and it gives you location, GPS location of the building to be sold on this earth. On this entire big earth, wherever the property is situated, that geotag photograph will nail the building and will give you the correct location of the building. So dear students, this is how we have learned the drafting of an agreement to sell, which is distinguishable from sale deed. This is a prior agreement and sale deed is the later agreement. So thank you very much, dear students.